This is Bloomberg Law with June Grasso from Bloomberg Radio.
A D.C. federal judge struck down President Donald Trump's order targeting the law firm of Perkins Coie, finding it unconstitutional. Judge Beryl Howell barred executive branch agencies from enforcing Trump's March 6th executive order, finding it was an unprecedented attack on the foundational principles of the American judicial system. She said in a cringe-worthy twist on Shakespeare's Let's Kill All the Lawyers, Trump's executive order, quote, takes the approach of let's kill the lawyers I don't like, sending the clear message lawyers must stick to the party line or else. Joining me is Professor Matthew Diller of Fordham Law School. Remind us why Perkins Coie was targeted.
So Perkins Coie was targeted by the Trump administration because it had an active role in representing the Democrats and Hillary Clinton in the 2016 election, and then again continued to do work on behalf of Democrat-associated groups around the 2020 election. So Donald Trump has had it in for Perkins Coie for almost a decade and has tweeted and done social media postings denouncing them for many years. So Perkins Coie has always been very high on his hit list.
The judge ruled that the order was unconstitutional. Tell us what the basis of her ruling was.
So first of all, it is a really remarkable ruling. And what's remarkable about it is not the results, because I think the result is what, everyone who is watching this case predicted. But what's remarkable about it is the thoroughness and clarity of her decision and its comprehensiveness. So in it, she both addresses the big picture issues that this executive order posed and its threats to the rule of law, and then walked us through step by step all the different particular ways in which it is unconstitutional, and there are many. And then finally, she addressed the government's defenses. And so I think the fact that it is so comprehensive and so clear will mean that it has great influence. And I think people are going to pay attention to this decision. Now, I haven't answered your question, so let me come back to that. So she found that the order against Perkins Coie was unconstitutional for a number of reasons. The first and biggest is that it violates the First Amendment in that it targets Perkins Coie for its political views, for its political activity, for arguments and representations it makes in court, and the Supreme Court has long held that the activity of representing clients in court and presenting arguments in court is protected by the First Amendment, and indeed that the ability to raise claims in court is really core to our democratic system of government. It violated rights of association in that it penalized clients for associating with Perkins Coie. It violated the rights of employees of Perkins Coie in a number of ways. So the thrust and biggest overarching issue is it falls within the scope of the First Amendment. But there are other problems with it, too, and Judge Howell walked us through those. So secondly, it violated due process because the executive order came completely out of the blue. Perkins Coie had no notice of any charges or claims against it and had no opportunity to respond. And so under our Constitution, when the government takes action against someone, they have to provide notice and opportunity to be heard, and that wasn't done here. And then she also found that certain aspects of the order violated the due process clause just because they were so vague and that, no one could really tell what was prohibited and what wasn't prohibited. And that section of the ruling particularly deals with the order's treatment of diversity, equity, and inclusion, DEI. And there have been a number of cases challenging the administration's actions around DEI program because they never really define what DEI is.
The series of executive orders were labeled as these law firms were national security threats. Did she address that?
Yes, she did. And the reason this comes up is because the orders talk about rescinding security clearances for individuals who work at Perkins Coie. And so that normally would be a national security analysis. What the judge really focused on is, first of all, the language of the order itself talks not in terms of national security, but in terms of national interest. And national interest is a much broader category of things. It seems to be whatever the president wants it to be, as opposed to national security. It's not actually framed around national security. But in terms of removing of security clearances, what Judge Howell said is that, well, it's very difficult for an individual to challenge the government's determination that he or she does not deserve, is not trustworthy enough for a security clearance. What was done here was not individualized determinations about whether each individual with security clearance posed a threat of any kind, but rather just a broad brush suspension of the security clearance for, I think there were 25 people at Perkins Coie who had security clearances, and they were all suspended in the same stroke with very little explanation other than saying in the national interest, which doesn't quite do it. And so what the judge said is that there was no individualized determination of whether these individuals actually were a threat to national security. That's what the problem was with that.
She said, the clear message is lawyers have to stick to the party line or else. And Paul Clement, who is representing Wilmer Hale in a similar case, told Judge Leon, if I have to stand up here and argue in front of the court today with one eye on how this is going to be perceived by the executive branch and how that's going to influence the interests of my other clients, well, I might as well go sit down. Do you see these orders as more of a warning to law firms writ large?
Yes, I think these are a threat to the legal profession and lawyers in general, and really to anyone who wants to push back against the Trump administration. And that's what's so striking about particularly the first part of these orders, which the first part starts with a statement of the purpose of the order. And it walks through all the reasons why the administration doesn't like Perkins Coie, and then doesn't disguise the fact that that's why the administration is taking these actions. And indeed, they issued a fact sheet that went with the Perkins Coie order that says Perkins Coie has filed lawsuits against the Trump administration, including one designed to reduce military readiness. So the orders are very upfront about how they are being triggered by the fact that these law firms have opposed Donald Trump. And so it's a clear warning that if you oppose the president, they will come after you.
The judge skipped having a trial, and went directly to a final ruling.
So that's not unusual that the judge skipped the trial. I would have been surprised if there had been a trial in a case like this, because really the order is, in my mind, illegal on its face, and there's nothing to have a trial about. When the illegality is plain from the document itself, there's really no point to having the trial. So that doesn't surprise me. What's striking about it is how fast she turned around the whole thing. All of this began to unfold, I think, in March, and we're already at the point where she has brought the case to final judgment with a 100-page decision, and it's only the very beginning of May. That is incredibly fast, and it reflects just how seriously she's taken the order to be a threat to our system of government and our democracy.
This is the first order of its kind, but there are other cases out there. Do you think that this decision will have an impact on the other cases?
So I think this decision will certainly help the law firms that are challenging other executive orders that are very similar. I think, as I said at the top, the result here is not surprising in the sense that it's pretty hard to defend these orders, that they feel illegal, they are illegal, and so the outcome is not shocking. But the eloquence and the thoroughness with which she has explained it will be influential, and I do think other judges will draw from that. I also think that language from this decision will show up in some of the reasoning in other challenges to Trump executive orders that are unrelated to the law firm executive orders, because there are other orders that are also retaliatory and were issued in order to send threats to universities, to individuals, and wherever the administration is seeking to punish people for things that they're entitled to do. I think this will serve as a precedent on why that is improper and dangerous.
She ordered the government, not to enforce the executive order. Do we expect the government to follow that? I mean, is there a way to track that this is really going to be observed?
One of the things that was striking about what happened here is just how open and blunt they were about it. For example, Perkins Coie reported that federal agencies began to cancel appointments with their lawyers, like within days of when this executive order was issued, and they would say, we're canceling this meeting because of the executive order. So now, going forward, of course, they won't say that, and they can't say that. And I don't expect them to cancel those meetings because I don't think that they necessarily wanted to cancel those meetings. I think they were responding to the executive order, and they themselves, the federal officials themselves were intimidated. Whether it has other, subtle continuing effects, it's hard to say.
When this first happened, some law firms reported losing clients, and I'm also wondering if some clients will still stay away from firms like Perkins Coie, knowing that they're not in the favor of the administration. So there's this sort of underlying threat.
So it's possible. It's possible that Perkins Coie won't recover the clients that it lost, and it certainly lost a number of clients. But, there are also reports out now about clients that are choosing firms like Perkins Coie, who stood up to the executive orders, because they support the decision that Perkins Coie made, and its bravery in standing up to what's a patently illegal order. And so now, the shoe may be on the other foot, which is, are there clients who are turning away from the firms that have settled with Trump because those firms, are they strong advocates or are they not strong advocates? So there's a way in which Perkins Coie has really bolstered its reputation for standing up for principle, for being a strong advocate, for taking risk in ways that I think are going to be attractive to clients.
Yeah, what do you think about the 9 other law firms that struck deals with the Trump administration, many even before an executive order was issued about their firm, and it's a total of almost $1 billion in free legal services?
First of all, this decision that came down is not surprising. So it's pretty predictable that these orders would have been stricken down. And so I think those firms were in a difficult position because they're victims here, right? The administration was in essence trying to extort benefits from them, and they agreed to that. They acceded to it. I think at a lot of these firms, they're probably rethinking whether that was a great idea or not, and we'll see what happens. And when I say we'll see what happens, there are a lot of unanswered questions about these agreements with law firms. So the one thing that's been made public is the dollar value of the pro bono work that the firms have agreed to provide. And then it says, for causes and clients mutually agreed upon between the administration and the firm, and they provide a few examples. But then since then, President Trump has gone around citing all sorts of things that he wants these firms to work on. And so if the administration follows through on that, then the firms will be put to the test of, do they really want to represent the United States for free in trade negotiations? Do they want to represent police accused of misconduct and excessive force? Even when in many of those cases, those police would have access to lawyers through the government that they work for. There was a whole range of things which Trump is now going around saying he's going to use these firms for. And it's not clear how the firms would respond to those requests. And so I think the firms may have opportunities to say, no, this isn't what we signed up for, and to back out of the agreement if the administration really pushes on these questions. And so to that extent, this decision gives the firms more leverage in how they implement the agreements.
And we'll see how the judges rule in the 3 other cases involving law firms that were targeted and decided to fight back. Thanks so much, Matthew. That's Professor Matthew Diller of Fordham Law School. This is Bloomberg. Does teaching middle schoolers about Islam, along with other religions, in a world culture and geography class violate the First Amendment's Establishment Clause? The Third Circuit Court of Appeals found that the curriculum taught by a New Jersey school district didn't show any of the hallmarks of religious establishment, ruling against the parents of a 7th grader. Joining me is an expert in the First Amendment, Professor Timothy Zick of William & Mary Law School. Tim, can you explain what the parents were complaining about in this case?
Some parents of middle school kids sued a school district after their children were exposed to materials on Islam in a course entitled World Cultures and Geography. And as part of that course, the children were taught some basic information about a variety of faiths. As it turns out, in addition to Islam, they were taught about Christianity, Judaism, Buddhism, and Hinduism. The challenge materials on Islam were presented in a portion of the course that covered the Middle East and North Africa, where, of course, Islam is the dominant religion. And to say the materials covered the general tenets of the faith, including some core Muslim beliefs. The parents claimed that the school district's curriculum was an establishment of religion, so that it violated the First Amendment's Establishment Clause, which says Congress shall make no law respecting an establishment of religion. So that was the claim that they litigated.
Were they only complaining about the Islam component of this?
Yes, they were only complaining that Islam was, in their view, not just covered in the way I described it, but actually being sort of proselytized students in a coercive way. So that was the sort of nub of their complaint, that their children were somehow being coerced to practice Islam or accept it as some true belief system.
And the court relied on the Supreme Court decision in the case of Kennedy versus Bremerton, which is about the high school football coach who wanted to pray on the 50-yard line after games.
Well, that's one of the recent cases where the court has been reconsidering, I guess I'll use that term, its Establishment Clause jurisprudence or doctrine. So in that case and others, it's sort of jettisoning some tests or standards it's used over the years to determine whether or not there's been an establishment of religion. They're doing it with free exercise as well, but particularly with establishment here. So you're right, that is the case involving the high school football coach who prayed on the 50-yard line. And the school district had terminated his employment because of that. They feared that letting him do that, permitting him to do that and employing him would be viewed or perceived as an endorsement of religion, which at the time was one of the standards the court was applying to determine whether the Establishment Clause had been violated. So in Kennedy, the court says, no, we don't do that anymore. We're not asking about whether someone mistakenly perceives that as endorsing religion. We're not using an old test that was called the Lemon test from a case way back. We were going to ask whether or not the practice is, in essence, sort of consistent with history and tradition. So as in other parts of the constitutional landscape, the court has moved steadily toward this notion of determining whether there's been a violation based on what history and tradition tell us.
How did the Third Circuit analyze it in this case?
Yeah, the Third Circuit spent some time trying to figure out how to apply that test, history and tradition, to these circumstances. One of the problems, of course, is that at the founding, there were really no free public schools. So a dispute like this could not have arisen. So they sort of generalized to, well, what did official establishment of religion look like at the founding when you had sort of state-established or sanctioned churches? So they relied on a number of different factors, the Third Circuit, mostly boiling down to whether or not the school children had been coerced into practicing a religion or punished for not practicing it. Were they being sort of led through some kind of religious ceremony rather than a sort of secular curricular exercise? Were they, as a parent's challenge, being proselytized into sort of accepting or believing the tenets of Islam? And on each of those points, the court said no. This was a secular exercise. No student was forced to adopt any of the tenets of Islam as they worked through the course materials or otherwise compelled to practice Islam. They were essentially just teaching kids about other faiths, which is not, the court said, coercion of religious belief. So context is key, the court said, and this was, again, part of a secular course on world culture and geography.
I'm not saying it happened in this case, but in the football coach case, I mean, it seemed like some of the kids were feeling coerced into praying with the coach. You know, there were concerns perhaps about whether the coach might treat them differently if they didn't pray with him. But the Supreme Court dismissed those. I mean, what does it take to feel coercion?
I think that's an open question. There was a dispute about the record in the Kennedy case, the football coach case. Obviously, the dissenters felt that kids were being coerced, even if subtly. to participate in an exercise of prayer. The Supreme Court saw it differently. They said he mostly prayed by himself. He wasn't sort of telling the students to come. In fact, they were busy doing other things while he was praying at the 50-yard line. One of the main incidents in that case was about the opposing team and their students coming to pray, and that, of course, isn't coercion of his players. So it's not clear exactly what the court would require in order to find that someone was coerced. I suppose if you made it part of their performance evaluation, whether it's a sport or their grade, to sort of participate in what's effectively a religious ceremony, that would constitute coercion. But in the Kennedy case, the court just didn't read the facts that way. At least the majority didn't.
So Americans United for Separation of Church and State said that this case had all the hallmarks of a manufactured controversy by far-right groups. I mean, bringing a lawsuit over such a limited part of the curriculum might be seen as an overreaction.
I mean, this is part of a larger sort of culture war around curriculum and books and parental objection and parental control over what students are exposed to in the classroom. And, if you understand sort of what establishment is historically, traditionally, and otherwise in the court's doctrine, this seems like a very weak case. And it is, because, of course, the students aren't being sort of paced through some kind of religious ceremony. They're not being graded on accepting as true tenets of Islam. Maybe most importantly, they're being taught about all sorts of faiths. And I think, the parents are objecting to what they consider to be sort of an anti-Christian sort of mindset in the schools, where if a student mentions, Jesus Christ, they're shushed and they can't say that, but here's the school district sort of teaching about Islam. But again, as the court said, the Third Circuit, context is key. This is not an effort to single out or favor one religion over another. It's part of a secular course. So, yeah, it strikes one as a very weak case.
I want to turn now to this project you have, and it's quite a project. You're compiling a repository of all Trump's First Amendment-related executive orders, lawsuits over them, and commentary about them. Tell us why you started this and what you want to accomplish with it.
So, for better or worse, I started out on this project at the urging of Ron Collins, another First Amendment guru, and he thought it would be a good idea, and I did too, to sort of keep track, sort of record of what the Trump administration is doing as Trump is signing, literally over 100 executive orders in the first 90 days of his second term. Close to 20 of those actually impact or affect free expression. So my resource, which is being hosted at First Amendment Watch, which is the First Amendment website, has those orders, but also the now approximately 40 lawsuits challenging various executive orders and provisions of those orders on First Amendment grounds. And then we thought it would be a good idea sort of keep track of the commentary and analysis, which gives you a sense of just how broad and deep this agenda that the administration has adopted is. So the document currently is sort of a Word document, stretches over 50 pages. And that's in roughly 100 days of the second Trump administration. And it just shows no sign of slowing down. So part of the reason I did that, not just to keep a record or an archive of this period. So imagine, back in the McCarthy era, someone was actually sort of keeping an archive or record of everything that was going on. So we set out to do that. But it's also pretty common for people to say to me, well, all presidents clash with the press and they all create free speech controversies. Isn't this just business as usual? And I think this document speaks for itself. If you go and visit it at First Amendment Watch, it's clearly unprecedented. Sort of a whole of government, whole of society use of executive power to control and chill expression. And I think, again, the document sort of speaks to that. And I don't think it's sort of an unwarranted panic of any kind. I mean, it's clear in the court that judges are viewing much of what's going on here as troubling. So one judge, for example, in response to one of these executive orders that target the law firms based on their causes and clients, he said, it chills my spine what the administration is doing here. So I wanted to keep a record of that, to keep track of just how many different aspects of society are being affected by the stroke of a pen, essentially, the use of executive orders. And I have to say, he's managed, President Trump, to reach law firms, universities, libraries, laboratories, museums, corporations. As I say, it's very broad, very deep, and to me, as a First Amendment proponent, very troubling.
And for those who want to take a look at the breadth of these First Amendment-related executive orders, you can go to firstamendmentwatch.org. And Tim, I know you intend to keep this up to date going forward, and we'll see how long this compilation is at the end of 4 years. Thanks so much, Tim. That's Professor Timothy Zick of William & Mary Law School. Harvard has come under repeated fire from President Donald Trump and his conservative allies who accuse it and other elite universities of ideological bias. In the latest escalation of the clash between the Trump administration and the nation's oldest university, the administration announced today it's blocking Harvard from new research grants due to concerns over, quote, responsible management. Just last week, Trump said in a social media post that Harvard would lose its tax-exempt status. Joining me is George Yin, Emeritus Law Professor at the University of Virginia and former Chief of Staff of the Congressional Joint Committee on Taxation. George, will you start by explaining why most universities have tax-exempt status and what it means?
Well, here we're talking about a particular category of tax exemption. It's under 501c3. And under that provision, there are a series of conditions that must be met to qualify. The organization must be operated exclusively for certain qualifying purposes, which would include education. No part of its net earnings may inure to the benefit of a private individual. The organization is not allowed to engage in any substantial lobbying activities or engage in any political campaign activities. And finally, the organization may not engage in activities that are considered contrary to national public policy. So those are the basic requirements. The benefit of the status, there are several benefits. A main benefit is obviously the exemption of the organization's income from taxation. But there are other very important benefits. The most common one people know is the ability to deduct your donations to these organizations as a charitable contribution. And in addition to that, there are some additional benefits, such as the availability for tax-exempt bond financing. So there are significant tax benefits. There are some very specific conditions that have to be met to qualify under C3 status.
Trump wrote in a post on Truth Social, "We're going to take away Harvard's tax-exempt status. It's what they deserve." He didn't say why, but he had previously said it should lose its tax-exempt status and be taxed as a political entity if it keeps pushing political, ideological, and terrorist-inspired supporting sickness. I mean, can a president just take away a university's tax-exempt status?
The short answer is no. There's a well-established legal process for granting the status and very infrequently revoking the status. It involves an application to the IRS, and then subsequently the IRS may review the status and recommend a revocation of that status. These decisions are not made just by order of the president or any other top governmental official. The decisions are required to be made in an even-handed, nonpartisan way by the IRS. Some of your listeners may recall a big controversy that arose in 2012 or 2013 regarding the alleged discrimination by Lois Lerner, who at the time was the head of the IRS's exempt organization division, against applicants for tax exemption which had a Tea Party affiliation. When this story came to light, the House Ways and Means Committee examined the case and actually made a referral to the Justice Department for possible criminal prosecution of Ms. Lerner because she had acted not in an even-handed and nonpartisan way, according to them. I researched this matter very closely and concluded that the evidence presented by the House Committee to the Justice Department was laughable and did not support in any way any wrongdoing by Lerner or the IRS, and the Justice Department subsequently agreed. The conditions for C3 status are somewhat vague and certainly present a challenging administrative responsibility for the tax agency. But I thought the evidence simply showed the IRS doing what it's supposed to be doing, which is to follow up and investigate credible leads regarding the qualification of an organization for that status.
Harvard said it would be an unlawful misuse of the U.S. tax code section, which is entitled Prohibition on Executive Branch Influence Over Taxpayer Audits and Other Investigations, which makes it a crime for the president or other executive branch members to directly or indirectly request that the IRS investigate or audit a particular organization. A spokesperson for the White House said afterwards that the IRS actions were independent of the president and that any audit or investigations were initiated before Trump's post.
Yeah, you're absolutely right. And there actually are several issues, and let me just run through them. The first thing Harvard is arguing, and this is under Section 7217 of the code, that it's a felony for the president, vice president, their staffs, and every cabinet member other than the attorney general to direct the IRS to conduct or terminate an audit of any taxpayer. And so the argument is that the president's assertion at the outset could be interpreted as directing the IRS to begin a review of Harvard's tax status in violation of that provision. Now, it's true that the president, thanks to the 2024 Supreme Court case, Trump v. U.S., the president may claim immunity from criminal prosecution by reason of the holding in that case, so long as the president is found to have been performing his official duties rather than personal actions. The argument would be that his responsibilities include taking care that laws are faithfully executed, and so the president might claim, well, directing the audit and challenge of any taxpayer's exemption is part of that duty. It's important to note, however, that other people are also subject to 7217, in particular, virtually all the cabinet members, the vice president, and their staffs. And they don't have the same immunity that the Supreme Court found in that case. So if, for example, the president asked the vice president or the Treasury Secretary or some staff members to follow up on his assertion and to direct the IRS to take that action, those other people could be prosecuted and be vulnerable. Now, the second point you made, which was the White House subsequently saying, well, actually, Harvard was being scrutinized even before the president spoke. So the president, in that sense, really didn't initiate any particular action against Harvard. That action was already occurring. So therefore, the 7217 provision doesn't apply. Well, even in that case, which is kind of arguable, but even if that's true, then his statements may run afoul of a different problem, which is the prohibition against disclosing confidential tax return information. Whether a taxpayer is being reviewed or audited by the IRS is protected tax return information. And under Section 6103, no officer or employee of the United States may disclose such protected information of any taxpayer. The violation is a misdemeanor, and a willful violation is a felony. Importantly, in addition to a fine, imprisonment for up to 5 years, damages, and costs, a willful violation results in discharge of the violator from federal employment. That's kind of an interesting thought in this particular case, would you say?
Forgetting about, whether it's a criminal violation or not, would that be a defense for Harvard? Let's say the IRS does end up taking away its tax-exempt status and they end up in litigation. Would that be a defense for Harvard to say no one in the executive branch is allowed to refer a case to the IRS?
Yeah, so that's an interesting question. I'm not sure the answer. My inclination would be that it's not a defense because, after all, again, the qualification for exemption is set out in the law, and if, in fact, notwithstanding how the case came about, that is, whether it was a cabinet member who directed, et cetera, Notwithstanding that, if after a review of the facts and the law, it was found that Harvard actually did violate one or more of the conditions for exemption, it's not clear to me that that would somehow absolve Harvard of that misconduct. But I'm actually not aware of any specific instance where that has happened, mainly because the 7217 has been rarely invoked because, of course, presidents and vice presidents and those people, they are supposed to be aware of it, and they tend to kind of make sure that they don't violate that.
Let's say that this does go, as I said, to litigation. What would be the issue in the case?
Well, I don't know. I mean, it goes back to your original point, which is what is the basis for the assertion that Harvard doesn't qualify for tax exemption? The only statement that I've seen so far was the one that you stated earlier, which is the president called Harvard a political entity. And I don't know what that means. I'm not aware of that term being in any aspect of the tax law in this area being used. He may have been saying they have been active in political campaigning. That's about the closest thing I can think of. And if that's true, that would be a violation, and that would cause or might cause Harvard to lose its exemption. But of course, you'd have to prove that. Just simply saying it, and I don't know what political entity is, but simply saying it doesn't necessarily mean that that has been violated. So maybe that's, the basis that they would argue it. But again, I don't know. I haven't really seen any arguments to support why they would be challenging the exemption. I wanted to add one additional thing because it's something that I think is particularly applicable, or may be particularly applicable in this case, and that I haven't seen it mentioned. If the president, like his apparent use of tariffs, is treating his claims against Harvard as part of a larger transaction to achieve some broader objective, then he and his cabinet members and other executive branch assistants should be aware of an anti-extortion provision that's also in the tax law. This is Section 7214. Under that provision, it's a felony for any officer or employee of the United States in connection with any revenue law to demand, accept, or attempt to collect, directly or indirectly, anything of value for the compromise or settlement of any charge or complaint for any violation or alleged violation of the revenue laws, except as expressly authorized by law. So, for example, if threatening Harvard's tax-exempt status is really simply a way to get Harvard to change some of its practices and policies, perhaps its DEI policies, if you will, that have nothing to do with tax exemption, then this provision might apply because it would be a form of using the revenue laws to extort some other thing of value. The penalty in that case is, again, a fine, imprisonment for up to 5 years, damages, costs, and again, discharge from office. So anybody, perhaps other than the president, would be potentially vulnerable for that penalty. My own guess, and it's just a guess in this case, is that it would never come to that. That is, my guess is that this issue would get resolved in some other way, whether Harvard would concede some things or whether the White House would back off on some things. I frankly don't think it's credible to think that Harvard's exemption would be taken away. But again, I certainly haven't delved into all of their activities.
There's a lot going on between Trump and Harvard, so perhaps this one will never come to fruition. Thanks so much, George. That's George Yin, Emeritus Law Professor at the University of Virginia. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.